Hi everybody, welcome to the Supreme Court show. This case is Acheson Hotels v. Laufer, and the oral arguments are set for October 4th. As always, I'm just trying to pull out the arguments from both sides in the case without giving any opinions on what's right or wrong, just trying to understand the arguments. So the context, Deborah Laufer has sued over 600 hotels, including Acheson Hotels, claiming that they failed to post accessibility information on their website in violation of the Americans with Disabilities Act. However, Laufer never intended to visit the hotels that she is suing, as she's a self-appointed tester. So the question in this case is whether a self-appointed Americans with Disabilities Act tester has Article III standing to challenge a place of public accommodation's failure to provide disability accessibility information on its website, even if she lacks an intention of visiting that public place of accommodation. So it's whether she has standing is the main question in this case. So the main arguments from the petitioner side are to establish standing, Laufer must demonstrate a concrete, particularized, and forward-looking injury, and she has not done so. Laufer cannot establish standing based on her alleged informational injury, so the injury of not having the accessibility information on the website. The alleged injury is not concrete, it's not particularized. A lot is turning on this Havens Realty case, which was a similar case where two testers caught somebody violating the Fair Housing Act instead of the Americans with Disabilities Act. And so a lot of the argument will be on whether that case applies to this one in terms of the standing. And lastly, this court's informational standing cases do not support Laufer. Laufer cannot establish standing based on her alleged stigmatic injury. She has not experienced and will not experience the type of discrimination that gives rise to Article III standing, and the emotional injuries do not give rise to Article III standing. Laufer's interest in enforcing the Americans with Disabilities Act does not give her standing. And lastly, at a minimum, there is no longer a case or controversy because Laufer has already received the information she seeks. The websites have already changed, have already provided the information, and she knows whether there's accessibility at the hotels or not. Now, the arguments from the respondent side is that Havens Realty, this case, forecloses Acheson's challenge to Ms. Laufer's standing. Havens Realty reasoning squarely applies to reservation rule testers, so it also applies in this case. Ms. Laufer experienced actionable discrimination when she encountered an unlawful barrier to her full and equal enjoyment of Acheson's reservation services, and Acheson's efforts to distinguish this case from Havens Realty fail. Havens Realty was correctly decided, should not be overruled. A person who experiences discrimination suffers a concrete injury independent of any downstream consequences. So the discrimination occurs as soon as there's no information on the website that they're hoping to get access to. History and tradition confirm that the discriminatory denial of services by a place of public accommodation inflicts a concrete injury. Acheson's public policy arguments are misplaced. And lastly, Laufer's claims are moot only because she dismissed her complaint with prejudice. So those are the arguments from both sides. The oral arguments are scheduled for October 4th. I will have a link to the oral arguments. I will stream them on this website. So there'll be a link in the description when that occurs. And lastly, when the opinion comes out, I'll make a video for that as well. So thanks for stopping by the channel, and I'll see you in the next video.